The first one is Rott versus Rott. It is a mini oral argument on the application, which means you each have 15 minutes. And Ms. Stewart, you may reserve some part of that, but we hope that you will try and manage that yourself, and you may proceed.
Okay. Good afternoon, Your Honors. My name is Melissa Stewart, and I am here today on behalf of the plaintiff, Doreen Rott. I would like to try to reserve 2 minutes of rebuttal time, and I will manage it on my own. Your Honors, we're here today for first to discuss whether the Court of Appeals clearly erred in its application of the law of the case doctrine, and then also to look at 2 provisions of the Recreational Land Use Act. I'm turning first to the law of the case doctrine. To give this court a bit of context, this case was decided, there were 2 applications for interlocutory appeal to challenge 2 rulings arising from the motion for summary disposition. One was that the Recreational Land Use Act applied, and one was that a question of fact regarding gross negligence remained. Now, the Court of Appeals declined to hear my client's interlocutory appeal challenging the application of the RUA for the reason that it was not persuaded for the need for immediate review. It did grant the defendants interlocutory appeal, and it issued an opinion addressing the issues of gross negligence only. The orders were entered and the case was dismissed, and we filed our appeal as of right, now trying to challenge the trial court's ruling as to the applicability, of the RUA. And the Court of Appeals decided that it had already tacitly approved the application of the Recreational Land Use Act to our to the issues in this case. We submit that this is clearly erroneous because this court's case law is quite clear in People versus Poole, in Grievance Administration versus LePayton, and even as far back as Mullooly versus York Heating and Ventilation, that a denial of an interlocutory appeal request is not considered a ruling on the merits, either implicitly or explicitly. And so when we're asking this court to rule that the Court of Appeals' use of the doctrine was clearly erroneous, we're just asking this court to apply the law of the case doctrine as it's been applied for generations. Are there any questions about that for me?
I appreciate your taking a breath there. Let me see who has questions, and we'll return to you if there aren't any. We'll start with Justice Cavanagh.
I don't have any questions.
Justice Welch.
No questions at this time.
Justice Zara.
No questions at this time. Thank you.
Justice Viviano.
No questions. Thank you.
Justice Bernstein. Do we still have Justice Bernstein? Justice Bernstein, you might be muted. Justice Clement, let's go to you, and I will return to Justice Bernstein if we're having technical difficulties again.
No questions right now. Thank you.
Okay, counsel, you may continue. I probably will interrupt you again to, when I'm sure I have Justice Bernstein on the line to see if he has questions.
Kind of turning more to the meat of this case, I wanted to discuss 2 aspects of the Recreational Land Use Act. I think it's important to note that the analysis offered by the Court of Appeals is dicta. So it's not binding, but this is a published decision, and it's already starting to impact jurisprudence regarding the Recreational Land Use Act. So this is why we're asking this court to look at it. So the first thing that we want to look at is the phrase "for the purpose of," and we're asking this court to determine whether it modifies the consideration paid or whether it refers to the specific activity that the individual was engaged in at the time of injury. Oh, excuse me one second. Throughout the course of litigation and the appeals, the parties have operated under the presumption that the phrase refers to the specific injury, the specific purpose on the land at the time of injury. my client maintains that she was on the land for the purpose of attending a party, and she found herself on the zip line to end a fight with her brother. The defendant, for his part, says she was on the zip line for the purpose of zip lining, which he classifies as a recreational activity. The consideration issue is really a non-issue in this case. No consideration was paid, and so that doesn't really have any bearing on the issues here. That's a known thing. This court in Neal has given the guidance that has the parties, I submit, believing that the phrase modifies a specific activity, because Neal says that the RUA applies if a person is injured while on the land of another, they haven't paid for the use of that land, and they're using a land for the specific purpose at the time of injury. So the Court of Appeals seems to acknowledge that there is some significance to the reason that you're on the land at the time of injury when it notes that the trial court didn't err in its determination that at the time of injury, my client was on the land for the purpose of ziplining. But it also offers some problematic language, which the Court of Appeals in a later case, McBride, I believe is the case, relies on. So the language at issue here is a plain reading of the statute does not lend itself to plaintiff's interpretation that the statute requires a person to be on the property for the purpose of recreational activity for the statute to apply. Plaintiff's assertions that she was harassed by the defendant into riding the zip line are irrelevant. That reading is not supported by the plain meaning of the plain reading of the Recreational Land Use Act. It's not supported by Neal, and it's not supported by the Court of Appeals' own decisions in Taylor versus Matthews and also Winnecke versus Welch. So with this application, what we're really asking is for this court to return equal weight to each of the elements of the act instead of giving consideration the outside weight that the Court of Appeals has given it in the decision below. Again, I'll ask if there's any questions before I move on.
No, I appreciate your pausing, and let me see if I have Justice Bernstein back on the line. I haven't gotten any confirmation about it, but Justice Bernstein, are you here and do you have any questions? It's a mystery today. We're just making it interesting. Anybody else have questions for counsel at this point? Okay, you may continue or you may reserve some time, up to you.
I'm just gonna finish what I've got real quick, if that's okay. The last issue is whether ziplining itself falls within the purview of the Recreational Land Use Act. We submit that it does not. Thus far, jurisprudence regarding what activities fall within the Recreational Land Use Act have turned on why a person is on the activity. We submit that's only part of the inquiry. It also matters if the land itself is relevant to the activity. So if you're looking at, for example, hunting, trapping, fishing, the land is required because that's where the natural habitats exist. They exist on the owner's land. Whereas with snowmobiling, hiking, camping, ATV riding, it involves an interaction with the land itself. So the land, the owner's land where the individual is permitted to use without pay is essential to the activity. And that's where it makes sense to apply the Recreational Land Use Act. By contrast, ziplining is a ride built along a fixed track and has absolutely no specific need to be outside. You can zipline in a gym, and you can also find them inside indoor recreation venues. These are places where things like beach play, motorcycling simply can't take place. So while the RUA certainly allows for an expansive definition of recreational activities, it's not limitless. And as I noted, the jurisprudence thus far has covered why the activities are engaged in, but the land itself is important. The RUA protects people who open their land to others for recreational activities. If the land is irrelevant, then it stands to reason that the activity is beyond the scope of the RUA, such as the case with ziplining.
You're pausing again, and I really appreciate it. Anybody have any questions for counsel at this point? Richard, do you have, Justice Bernstein, do you have any questions?
Hi, Chief. No, I don't have any questions. I'm just glad to be able to participate.
Oh, excellent. Okay, you may continue or reserve time, up to you.
I'm all set. I'll reserve time. Thank you.
Thank you. Mr. Paul, you may proceed.
Good afternoon to the court. My name is Ronald Paul, and I represent Arthur Rott, the defendant in the principal action, the appellee here. I will address very briefly, frankly, the issues that counsel has addressed in the same order so that it makes some sense. I will say this, that I primarily will be relying on my brief and what I consider to be an appropriate and correct ruling by the Michigan Court of Appeals in this case. First of all, with regard to the law of the case doctrine, I think there's really no dispute that for the court to consider gross negligence, it necessarily had to have assumed that the Recreational Use Act applied in this case. Bear in mind that the court, when it faced this issue initially, had two applications for interlocutory appeal. It had mine and it had the plaintiff's. It denied the plaintiff's, granted mine, and in doing so, or granted the defendant's, and in doing so, necessarily caused itself to have to consider whether the act applied and whether gross negligence was proven under the act. The fact that plaintiff suggests that the court denied an interlocutory appeal and therefore the case law in that regard applies to this case, frankly, is not accurate, because it did more than just deny the plaintiff appellant's interlocutory appeal. It accepted interlocutory appeal as approached by the defendant appellee and decided the issue in the underlying case. So I think they properly applied the law of the case doctrine when the issue came up on the second occasion. Are there any questions on that issue?
Thanks, counsel. Let me see. I'll start with Justice Cavanagh.
I just have one. The Court of Appeals order granting your interlocutory app for leave contain the standard language that says limited to the issues raised in the application?
Yes, I believe it did.
So where do we, if that is the case, and a particular issue was raised and denied in plaintiff's app, why do we make the leap that, well, they were implicitly taking that issue?
Because the issue of gross negligence would be a non sequitur if it wasn't under the application of the Recreational Use Act. It would not have been worthy of consideration. It wouldn't have been an issue.
But by the court's own order, they limited their review to an issue that, I mean, they didn't implicitly, they limited what their review was. So they explicitly said they weren't reviewing the other order or the other issue, correct?
That's correct. But I think it basically is a single issue. Gross negligence doesn't arise unless the Recreational Use Act applies. It's not two different issues.
Well, I agree that it would seem to make most sense practically. Like, why are we going to decide gross negligence if we still want to have a debate of whether or not that is the proper standard? So maybe it doesn't make much sense sort of logically, but it doesn't, there's nothing precluding you from finding, yes, it's gross negligence. Well, now let's go back and see if that statute even applies. Correct?
Yes.
Okay. All right, that's all I have. Thank you.
Justice Welch.
Thank you, Mr. Paul. I just have a quick question. In reading the statute, the Recreational Land Use Act, are there any limits on what's covered in outdoor recreation? I mean, is there anything you can think of and that's not covered?
Well, I haven't thought of it in that context, to be honest with you, Your Honor. And I guess perhaps something that doesn't involve the use of the land at all, which may be, for example, paragliding or something of that nature. There could be an argument that they weren't actually using the land. In this particular case, I don't think that's true or accurate, because in order to zip line, you have to have a beginning and an end, both of which are on land. And the point of zip lining is to get from one position on the land to another position on the land by riding on the line. The land is an integral part of zip lining, regardless of what the plaintiff argues that it is not. While you're on the zip line, you're not touching the land, but without the land, you don't have a zip line. Paragliding, parachuting, maybe a little different. I really haven't analyzed it on that basis.
Okay, thank you.
Well, let's analyze it a little bit more. What about a pool that's in the ground? If you come over to my house and I don't charge you to use my pool because you're just enjoying yourself in my pool, but I neglect to tell you that I, of course, naturally, because it's me, keep a shark in it, a blue shark, so you can't really see it in the water, and you're attacked by my shark in my pool, because it's outside and in the land, is it covered by the act? Does that allow me to keep sharks in my pool?
Again, a scenario I haven't thought of, and there are a myriad of scenarios, I suppose, that we could come up with. My inclination, frankly, is to say, yes, that would be covered.
All right.
But again, it's not something I've spent a lot of time thinking about.
Well, the act has to have some limiting.
And wouldn't that be a situation if we know we have a dangerous animal in the pool? Wouldn't that be considered gross negligence? Wouldn't that become outside the statute by virtue of its being gross negligence?
I think you make a very good point that it's probably gross negligence, but I'm still trying to focus on what limiting principles help us figure out what outdoor activities are covered and what aren't. And one might be whether there is some other structure that I have myself put on my land, like a pool or a zip line or a playground or a slide. I don't know if that's a limiting principle that might help us figure out what activities on the land fit and what don't, but what do you think about that limiting principle?
Well, I think one of the initial cases under the act, and I forgive me, I can't remember the name of it, but it involved a motor raceway, which was clearly a construct on the land that was being used by the people there to race cars. And that motor raceway was considered to be part or covered under the Recreational Use Act. So I don't think it's a matter of constructs on the land. And again, another example of that might be the sport of racing motorcycles. There's moguls or an amateur ski hill, for example, where somebody puts moguls in on their ski hill on their property. Those are artificial constructs to some extent, but I think should still be covered by the act.
Okay, thank you. Justice Arrow.
No questions, thank you.
Justice Viviano.
No questions.
Justice Bernstein.
Hey, just one quick question. You know, and I appreciate the arguments on both sides. I'm just going to ask a question that, you know, that I just want to get a sense of kind of where you're at on this. How do you respond to the fact, and I understand it's not as intricate as the other issues of this case, but I just want to get a sense, how do you respond to the fact that in this situation, the individual that got injured, they were heavily encouraged, if not kind of ultimately, I mean, highly encouraged to participate in this? I mean, how would that factor into this at all? It wasn't that they asked to do it. It wasn't that they wanted to really participate. It was almost as though they were almost forced into doing it. And I'm just curious how you would respond to that.
It's difficult to respond to that in the context of the act itself, Justice Bernstein. And the reason I say that is this: if this were a run-of-the-mill negligence action, the fact that she was coerced, if you will, into riding the zip line might mitigate against any finding of comparative negligence on her part. But we don't have the issue of comparative negligence because this isn't a general negligence action. So I think in this context, it's not significant.
Thank you. Thank you for the answer. And I have no further questions.
Oh, thank you. Justice Clement?
No questions, thank you.
Okay, counsel, you have a little bit of time left if you would like us to hear anything else.
I did.
Yes.
Oh, sorry. I thought you meant me.
No, sorry, Ms. Stewart. Mr. Paul has a bit of time.
Yes, I would like to mention a couple of things with regard to for the purpose of language. I think, you know, I looked at that argument both in the context of the Court of Appeals opinion on it and what plaintiff was saying. And I did not mean to be flippant with regard to what the plaintiff appellant was saying in her argument, but it seems to me that in this case, it's a distinction without a difference, because if in fact we accept the plaintiff's argument that she was there for the purpose of having a picnic and not for the purpose of riding the zip line, but nevertheless got hurt riding the zip line, we're right in the context of the Neal versus Wilkes decision, where they said one's initial purpose for entering the land is not relevant. I think this court has already ruled on that issue. And then lastly, I'll just finish up real quickly and find out if there's any other questions. But lastly, as I think I said a few minutes ago, land is essential to the issue of ziplining. You have to have a beginning and an end. So I think it clearly falls within the context of recreational use. And, you know, I look at the case of Otto versus Inn at Watervale. That plaintiff wasn't on the land for the purpose of stepping into hot ashes. That young lady was on the land to have a picnic. Different purpose, and certainly stepping in hot ash is not a recreational use. So I think those issues have really been decided by the court. I'd ask the court to deny leave to appeal and affirm the Court of Appeals opinion.
Thank you, counsel. Ms. Stewart, now you may proceed with your rebuttal time.
Thank you, Your Honor. I do just want to offer two quick counterpoints. First, regarding a limiting instruction or limiting principle, I think there are examples of situations where the Recreational Land Use Act doesn't apply. And in fact, in his dissent to the Neal decision, the now retired Justice Cavanagh cautioned that if we take this too far, the act is going to apply to regular backyard birthday type activities, you know, potlucks, pin the tail on the donkey, things like that were never contemplated by the writers. And an example would be, for example, if I invited folks over to my house for an outdoor evening poker game and you tripped on a step because it's outside and poker is a recreational thing, would we be having then, would the Recreational Land Use Act apply? Under the logic that the defendant asks us to adopt, it would. But if that poker game were inside my house, poker doesn't need to be played outside. If it were inside my house and you tripped and fell on a step in a darkened room, there's a published Court of Appeals decision, Blackwell versus Franchi, that says that there is a question of fact regarding negligence. So that is that's an illustration of why the land itself is essential to the activity. A zip line does connect from point A to point B, but that can be a deck to a tree, or it can be one end of the gym to the other end of the gym. It's not the land that matters. And that's why ziplining doesn't fall within the purview. And the other issue I want to provide another example regarding the for the purpose language. What is troubling to us is the Court of Appeals saying the fact that she was harassed onto the zip line is irrelevant. Imagine a situation where you are on somebody's premises for the purpose of beach play. And as you were playing on the beach, you noticed somebody in the shallow waters beyond you flailing. You go into the water for the purpose of rescuing them, but you're still splashing and wading because the water's only knee deep, and you're injured because you trip on a rope or a log or something, some form of negligence. At that moment, technically, beach play is a recreational activity, but you're not doing it for recreation. You're doing it to save somebody who's in distress. So there are situations, not all of them, many situations are clear, but there are situations where you have to look at the evidence of intent at the time of injury. And although it may seem like a fun activity, splashing in the water, you're saving somebody's life. Or it may seem like a fun activity, ziplining, you're there because you're embarrassed that your brother has been giving you a hard time for a year. So all we're asking is for the court to give the statute the legislative intent behind it.
Thank you, counsel. Are there any additional questions for Ms. Stewart? Okay, thank you both for your presentations. The case will be submitted.